Magda's pleas for brevity seriously even before she made them, and produced what I think is the briefest document in the entire volume. And in a way, that's what I want to talk about. I want to talk as much about what's not there as what is there. But let's first take a look at some of the passages that I'd like to take special note of. This was a set of regulations issued in 1616, and the translation reads as follows. By the way, it should be mentioned, while I did translate this text, I had help from Wayne de Groot of Columbia on some of the convoluted sentences of 17th century Dutch prose. Representatives of the Jewish nation. This is the first time the group of emigres, new Christians, ex-conversos from Portugal and Spain, most of them with Portuguese roots, who settled in Amsterdam starting in the 1590s. This is the first document that mentions them as Jews, the first legal documents. Prior to this, they've been mentioned as the Portuguese nation, members of the Portuguese nation. So the very first, the very opening is a novelty. Having been so ordered, were summoned by the magistrates of the court, and they arrived in sufficient number. It has been found that some of them exercise very great and unchecked license to visit and converse with, and here it's not a matter of briefwechsel. This is sexual conversation with the women and daughters of these lands. So we have the Jewish nation on the other hand, and these lands, the people of these lands on the other. It's clear that they are foreigners. This not only causes great vexation in the city and its environment and in its environs, but produces other harmful results. No intention of tolerating, punishment, etc. To better warn the Jews and to prevent such excesses in the future which violate the good governance of this city and the constitution of this same Christian community. And one might ask why Jews visiting Dutch prostitutes is different in terms of the good governance of the city and Dutchmen visiting Dutch prostitutes. They will be admonished not to speak or write, and this is really the core of this very brief piece of legislation. They will be admonished not to speak or to write, and to ensure that nothing be spoken or written which could in any way serve to harm our Christian religion, point 1. Point 2, nor to attempt to entice any Christian person away from our Christian faith or to circumcise such a person. 3, nor to have sexual intercourse with any Christian women or daughters in or out of wedlock, even if they are of ill repute. Already been stated, but here it's put the three of them together. The three points that are made here are put in one sentence. And they are to comport themselves with others as well as with the good authorities of the city in all modesty according to the laws of this country and the specific regulations of this court, and particularly according to the resolution issued to them on May 2nd, 1612, of which more in a moment. And they are also to distribute this proclamation and warning to everyone of their nation, the intention to proceed severely, and to administer such justice as circumstances require in accordance with civil law as well as with public ordinances and decrees. So that's really the heart of what I want to talk about, what's there, and even more importantly, what isn't there. Perhaps I should, well, no, I think I actually will do this, discuss the May 1612 legislation in a moment. For a long time, there have been rather, I would say, clear models of the role of, or the place of Jewish communities in the Christian world for the medieval period and then for the Emancipation period. And the model for the medieval period, with all of its variations, is something based on a privilege, which is simply a private law. The Jews were governed by a separate law, by a separate legal instrument. And these charters were worked out through negotiations, and they differed greatly, and they're still the model for most Jewish communities in some variation in the early modern period. What we have here is a community that's established without a charter, basically. They began settling in the 1590s in Amsterdam. By 1603, they had a synagogue service. They didn't have a synagogue building designated for that purpose, but they did have services. And yet, there was no legislation concerning them. It's only when their settlement is in effect a fait accompli that we have this very meager set of regulations, which are supplemented by only a few other measures later. So this was not something that just happened to happen. That's at least my argument, because we see a similar pattern in France and in England with the same population. The same population, they arrive as new Christians. A blind eye is turned to the fact that they're escaping the Inquisition, and many of them are presumably Judaizing in one way or another. They establish their settlement. They become established in trade. And at some later point, their existence is recognized as a Jewish community sooner or later, or not at all. In the case of England, they never are really, there's never really a moment when Jewish settlement is recognized. They build a synagogue and establish a cemetery in the 1660s. There's no written agreement. I've called this an evasion, a tactic of evasion, and it's not just an evasion of clergy and guilds, although to some extent it is an attempt to evade the outcry, the inevitable outcry of members of the clergy and guilds. But what I'd like to argue is that it's actually an evasion of establishing rules and legal principles in a period of great ambiguity and uncertainty. At a period when there is movement away from the idea of privileges of private law, towards an idea of states in which all subjects live according to the same set of laws. They may have a subset of their own laws. We heard the term dual citizenship, something like that, but that the main framework for all groups is the one that is stated here as the constitution of the same Christian community. That becomes the constitution for everyone. It's a compromise position. It represents a tendency on the part of the humanistically inclined regents of the Netherlands to avoid taking action in religious matters. That is, we don't have a principle of the separation of church and state, but what we do see is a disinclination of the ruling body to interfere in matters of religion. And all of this has led to the stereotyping of early modern Amsterdam as being a place where toleration was enjoyed in a way that it hadn't been enjoyed elsewhere. And I say stereotype not because it's entirely wrong, but because the authority to coerce was still there, and it was left in the hands of the communities themselves. And I think here there is a clear parallel with with religious corporations, other religious corporations within the Dutch polity, organized the Calvinist clergy, the Reformed clergy, were organized in a consistory system, which if you were a member of the Calvinist church, and as I mentioned before, many people attended Calvinist churches without actually becoming members, but if you became a member, you subjected yourself to the discipline of the consistory. And there were various merchant colonies that had their own churches, and there was some combination of political and religious governance in all of them. This kind of organization in which you have a ruling body or ruler that chooses to avoid interference in religious matters, but very tight disciplinary action by the leadership of religious groups themselves, obviously is partly a product of the Reformation and coming to terms with a multi-religious society. It's also associated, I would say, with the process known as confessionalization, which was mentioned in the keynote address. The need in the Reformation period for the various religious groups that it had such fluid boundaries and continued to have fluid boundaries in the 17th century to create structures governmental, to create regulations, to create sets of doctrines. And so if you begin to look at it from this point of view, toleration is not a word that describes the governance of the society as a whole. And there's a Dutch scholar who wrote about this, Joke Spans, who introduced a term that's usually used in the 18th century to describe Dutch society, in the 17th century. She asserted that the Netherlanders adopted a disciplinary approach to religious dissent. What was different about it was the method of application. And she suggests that this pillarized structure, that's the term that was used, a pillarized structure of rigidly defined minority communities that were carefully monitored by the magistrates and strictly supervised by a board lay of elders, was the way this was instituted. This resulted, and I'm quoting her, this resulted in a society that was harmonious but at the same time highly authoritarian. I think this is reflected to some extent in this legislation. Let's leave it to the Jews to figure out their own governance. There is not only is there no legislation concerning where they're to live, what kinds of occupations they may deal in, that's dealt with later with another set of regulations, actually. They do not need to distinguish themselves in dress. They do not need to pay a special tax. They are expected to register their marriages, but everyone is expected to register their marriages. I mean, we get into the same questions of what about marriages of uncles and nieces that we see elsewhere, but the actual obligation to register the marriages is not different from the obligation of all Netherlanders registering their marriages. The legislation that's mentioned here by allusion is interesting, that the 1612 resolution, which was issued under pressure from the Calvinist clergy, and there's no question that the Calvinist clergy was the most hostile element to Jewish presence in Amsterdam. And in 1612, when the Jews, there were sufficient numbers of Jews to construct a synagogue, they began doing just that. And there was a huge outcry from the Calvinist clergy, who were calling not only for modesty. What's mentioned in the 1616 regulations is modesty. You have no sense of what's really going on in the 1612 regulations. which is actually a prohibition of constructing and using a synagogue. That regulation was made, but it was immediately circumvented by having a member of the municipal council himself buy the building that was under construction, and then it became his private building and it was used as a synagogue. So the same municipal council that had passed the regulation under pressure from the Calvinist clergy was complicit in allowing the synagogue to operate. The fact that in the Netherlands you have a new state that is still in many ways experimenting as to what shape its institutions will take place, no doubt contributed to the reluctance to define in a very clear way what the place of the Jews was. And as has often been noted, Jews had not lived in the Netherlands for centuries, and so there was no tradition of legislation along the lines of the medieval privilege, the medieval charter. There was no precedent. There is a kind of wait-and-see attitude in the regulations. Let the institutions develop as they will, and we will intervene as necessary. And that's certainly something that happened. I think another consideration that hasn't really been mentioned here, and I'm not quite sure why, I'm not sure even the word has been used, namely mercantilism, plays a role in that the priorities of state have changed. And one of the things that mercantilist regimes wanted to encourage was the immigration of commercial elements, this immigration and settlement of commercial elements. And Amsterdam, of course, very early on in the 17th century became an immigrant city with merchants and other urban elements, including craftsmen, coming from elsewhere in Europe. So again, there was no wish to restrict Jewish settlement, as you find, for example, certainly in Prussia, even at a time when Prussia is in favor of expansion, relying on an older set of assumptions about Jews and their place. There is a weariness with religious wars that undoubtedly contributes, a reaction to tyranny for which Netherlanders have very good antennae, and a wish to allow economically productive groups to be as free as they can in contributing to the expansion of Dutch commerce. So no longer is there any reason to, or I don't know if that's perhaps the best way of putting it, the Jews are not settling with a specific economic role designated for them. They're coming because Amsterdam is a commercial center. They're tied into the network of Atlantic commerce that is already established in Amsterdam. They're not fitting a special slot, although they may dominate one trade route, the trade route between Amsterdam and Lisbon. They're not serving the kind of function that Jews serve, for example, in Ashkenazi Jews in Venice, or the pawnbrokers and small moneylenders in the German states, or the managers of estates in Eastern Europe, in Polish lands, Poland, Lithuania. They have no particular function. In the 1630s, they are confronted with a certain degree of restriction in their economic activity, a regulation of 1632 denied them the full rights of burghers. This too was something of an evasion. That is, they could buy the rights of porters, but they were not in the same category as Christians when they bought them, in that they could not hand them down to their children. They were not inherited. They also were blocked from activity in certain guilds. But otherwise, nothing was stipulated in terms of how they would regulate themselves internally. Nothing was stipulated about cases in which a Jew and a Christian were bringing a lawsuit. And as I said, no special taxes, no residence requirements. They were permitted to buy land, they were permitted to carry weapons. And their status was really, it's very hard to define, and in a way it's hard for the historian to interpret because so much is missing. You could argue that the ruling elites of these countries were, and I include France and England, were adopting a policy of legal evasion as a means of attracting an important mercantile population, while at the same time keeping the clergy and the guilds at bay. But I think this is, while there's a good deal of truth to it, it's a simplification. I think it is important to note that the language of the regulation does not, while it requires Jews to avoid creating scandal, it doesn't use the language of blasphemy or infamy in reference to Jews. But at the same time, it's clear that there's an issue here that goes beyond the simple sort of standoff between the ruling elite of regents and the clergy. There probably was wide agreement that Jews had no business discussing religious matters with Christians. The ruling elites were not free of their own anxieties at this point about Jews, and they were not always at odds with the clergy. And just to sort of round off this introduction, many of you already know about the set of regulations that was never implemented, that was drawn up by the great jurist Hugo de Groot. In 1615, he was asked by the states of Holland, not by the Municipal Council of Amsterdam, but one step above, the states of Holland, to draft, he and another jurist, to draft a set of regulations, which was never implemented, which recommended a quite restrictive policy with an explicitly conversionist agenda. In fact, what happened was that in 1619, the states of Holland decided to allow the municipalities to make all decisions about the regulations pertaining to Jews with only one sort of universally applicable principle, that Jews should in no place in the Netherlands have to, or in Holland rather, be required to wear distinguishing clothing. That is, that was the only thing that the states of Holland actually legislated concerning the Jews. The rest they left to the municipal councils. When this was decided in 1619, it catapulted these 1616 regulations into the position of being as I said, the legal instrument ruling or governing the Jews of Amsterdam for the better part of 2 centuries. So I'd like to open, there are a number of issues here, and I'd like to hear what people have to say, and any questions or
Yeah. if I'm remembering correctly, this is around the period when there's all the turbulence from the remonstrant, counter-remonstrant business. Is that affecting a regulation of the Jews as some sort of backwash?
The voice of the Calvinist clergy is always heard, the Reformed clergy is always heard, and I don't know whether that had an impact here or not. Most people think there was some incident that angered a lot of people. Either it had to do with conversion, there were very few cases of conversion, but there were a few. Something scandalous, either a case of conversion or some very, what shall I say, public case of a violation of the sexual boundaries. The truth is that these sexual boundaries were violated all the time throughout the course of the 17th century, and no special action was taken against Jews. There would be regular roundups at houses of prostitution, and Jews would be fined along with the Dutch. But there was almost, I know of no cases in which there was specific action taken against Jews for having relations with either with their Dutch servants or with prostitutes. So it's hard, well, it's hard for me to say what may have precipitated it. We don't know of one particular thing, but that seems more likely than any particular pressure because of the tensions in this period.
Looking at the formulation of the oath and noting this remarkably Old Testament, how typical is this oath for other faiths? Of oaths for Jews?
Well, the whole issue of the Jewish oath.
I can't swear by Jesus. That's the.
Well, right. And so what we have here is an effort to standardize something that had obviously been done on an ad hoc basis, and probably Jews would suggest that they take an oath in a way that was acceptable to them to a court, and the court would either agree or not, and now it's being standardized. I don't even know whether this was actually used. This appears in the regulations. Whether it was actually used, I don't know. It's a rather mild case. It's typical, but it's mild in comparison with. These are curses that are, because Christians know the Hebrew Bible, they have access to them. They're accessible.
My question was typicality, so it is typical.
Yeah. It's typical, but I would say mild.
Can I add, along those lines, what was the Lutheran Church, the Calvinist Church's reaction? In other words, what did they threaten?
Well, they had no
if they
power.
could.
They had no power to.
But that's why they could threaten. If you don't have power, then you threaten.
You don't have power, you pressure. That was certainly what was happening. They were constantly calling for restrictions on the great liberties of the Jews, and asking for permission not to be granted for building a synagogue, for expanding a synagogue, and so on. And the municipal council, there's one very fine case. They complained about the Jews rejoicing in the streets on Simchat Torah, and the municipal council simply waited a day, and Simchat Torah was over. And this was, sort of the way things work. But the Calvinist clergy, while they were considered important, and they had their own power, they certainly did not have. They did not have any. They were not an official church, not even in the sense of the Church of England. They were the recognized church, but they were not an official church, and so they had no. There were actually Catholics sitting on the municipal council.
In my area, in Evasion chapter 12, you have the following provision. We're talking now about the 5th century problem. An Iranian who has a connection with a non-Iranian prostitute is Margazan. In other words, he's really violated the top. He's made this is as simple as you can get. You're worthy of death, but that's it. Good. Who's going to enforce it?
Well, certainly the Calvinist clergy could not enforce anything except within their domain, and they had no jurisdiction over Jews. But I think it's clear from the regulations that the Jews themselves are not really regarded as a jurisdiction, even though, in fact, they are given, they do have Bate Din and so on, but that's not the way they're regarded in the eyes of the law. But I would actually like to hear from some of the legalists here about the either parallels in the early modern period when things are so fluid institutionally, about evasion as a way of dealing with this fluid situation of transition, of movement.
Well, I've sort of, I mean, I can't answer this question because I don't know anything about the early modern period, but I just wanted to clarify the use of the term evasion, just for a lawyer, that was all.
Sorry?
The use of the term evasion, you mean non-regulation?
Not necessarily. Not necessarily, because it may even be in one case making a regulation and then subverting it.
It's called creative ambiguity. When you leave room for, you deliberately leave room for interpretation open because certain
Meaning
things-
keeping it ambiguous.
Yes.
Well, leaving room for interpretation one way or the other because the lines are not so strictly drawn and you don't want them to be for various reasons.
Or leaving it ambiguous or keeping silence, actually. I mean, there's so many issues here that aren't addressed.
I mean, I agree that they're not addressed in them, but it's interesting. But I think that the presence of the nation, which you called our attention to by saying that this is the first time the words are used, in this text, by calling attention to the non-tolerance of behaviors, you make explicit your tolerance of the presence of people, right? So you reject the behavior, but you accept the people.
Another thing that might be said, of course, about the term nation is its meaning in this period is a group of foreign settlers. A merchant colony would be referred to in the same language, and there are parallels here to the status of merchant colonies, the colony of English merchants in Amsterdam, for example, which also had its own church. The problem, of course, with Jews is that there is a historic issue between the Christian church and the Jews that doesn't exist between the Christian world and the English church. There are, I don't mean to say that there's an equivalence here, but I think there's certainly parallels to the way that merchant colonies were allowed to operate in Amsterdam.
Elizabeth and Bernie?
I wonder if either you or anybody else could expand your.
You touched upon it, but then you moved on. The question of blasphemy laws and Jews' utterances being taken as in some way subversive of or harmful to the interests of Christianity, and there being, I guess, a medieval assumption that almost anything a Jew could pray or say or do was inherently harmful to Christianity. If they were screaming Moshe Emet, the Torah to Emet on Simchas Torah, that might have been taken as a rejection of Jesus. Almost anything that Jews did could be seen as somehow blasphemous, and yet in the early modern period the construction is loosened and much more can be said that's not seen. So is there anything, any literature, any laws, anything that...
I think, again, it's the absence that cries out, and that there was a process of experimentation. Certainly the members of the Jewish community used self-censorship when they felt that something might scandalize the Dutch public. And of course, there's lots of speculation about the ban on Spinoza, whether this was for internal reasons or because there was fear that the Dutch authorities, and it's probably some combination of both. But this, I would say that the discipline imposed by this consistory-like community, the self-censorship was pretty efficient. That is, we don't know of cases. There were complaints by Reformed clergy all the time, and there were occasionally disputes, but they were disputes that must have been worked out privately. A lot was worked out privately. We see the same thing in London between the authorities. We don't know what was worked out privately.
In Germany, for example, there are censors. The states send people into the synagogue to make sure that people are not saying things that they shouldn't be saying.
Well, the Olena,
Right.
the Olena prayer was
Right.
a big issue.
So there's this tremendous fear that Jews are still uttering things that are blasphemous. And here it's touched on, but it's not.
Well, I think these are sort of the very subjective issues that are hard to articulate in law, and so they aren't. But we don't see images of Jews that are
It seems
that
remarkably
reflect.
liberal, actually.
There's a lack. I would say there's a lack of a demonized view of the Jew. There's an absence of the demonized view of the Jew that you see so vividly in the German states. You cannot find a single image from the Netherlands of a Jew that compares with anything that you're seeing in the German states. And so there's a more relaxed attitude. Of course, there's always the question of Protestant biblicism. And, you know, Netherlanders like to hear the name Aaron and Moses, and these evoke positive things for them. And there's an identification with the children of Israel. And I think here is really a break with the past, because whereas medieval Christians might identify with the patriarchs who were considered precursors to Jesus, or with the great figures who were considered good Christians of the Old Testament, they did not identify with the children of Israel, who are often demonized. But that's certainly not true with the Dutch, who regarded themselves, who identified with the children of Israel crossing the Red Sea, and they had lots of water images and real images of water to draw from in their imagination in their war with the Spanish and their achievement of independence from tyranny.
I was going to say, I think the point you started with, the sort of what you called evasion, the way in which there was no formal charter for the Jews in Amsterdam, and they just come up with this kind of backhanded, listen, be sure you don't do these following things which offend us, sort of thing. There is another side to it, or another element. There, in fact, was a tradition in the Low Countries generally, and in Amsterdam as well, of and a fairly consistent and careful one of regulation about foreign merchants. I mean, you made the point that this term nation, and as late as 1598, you have regulations about Levantine or Spanish. You have regulations or statements about these foreign merchants, and there was a long-standing tradition in the Low Countries about regulating the presence of Ponentine and Levantine Jews. And after the settlement in Amsterdam, in other words, after 1602 and so forth, you get the attempts to get charters in, I'm sure I'm mispronouncing it, but Alkmaar and Haarlem, and those again specifically refer to the settlers as foreign merchants of the Levantine and Ponentine nation. They use other terms for it, but that's the rhetoric. So there is a legal tradition here. It seems to me what's really interesting in what you raise is that fundamental question: why didn't Amsterdam ever formalize the shift to Jews? In other words, why didn't they ever issue a charter like everyone else had issued for Jews? And it's that transition.
The same question. You have the same question for England and France.
Well, again, France had a long tradition of formally chartering the Ponentine settlers. They had a term, and what was it, 720?
The Leg Patent of 1550, but they refer to them, but again, they refer to them as members of the Portuguese.
Right. So
The Portuguese merchants.
right, and that is a euphemism that is developed very carefully. It's a very careful legal language. It isn't just a kind of a vague term. And the rules and the regulations about that, there's antecedents and clear cut. Everybody's following exactly the same things from 1532 in Ancona. It keeps going straight through. What's interesting is that in Amsterdam, they allow them to, in effect, do what everybody knows they're doing already, and never then issues the formal charter to Jews. So, in a sense, maybe we can turn your position on its head, or think about it in the opposite way. It's not so much that they didn't regulate the Jews, and therefore there's something about their attitude, but it's rather that they too inherited this tradition of foreign merchant colonies. And at some point, they simply don't worry about the formality of the euphemism. What they're really giving up here, in other words, it's not that they don't create a charter for Jews, it's that they give up on the formal euphemism that everybody's been using and that they themselves used as late as 1598, and that is being used in the Low Countries in the first decade of the 17th century. So, in other words, the challenge facing them was not so much how do you regulate the Jews, but rather how much are we going to keep pretending that these people are Portuguese? And they ought to simply stop, and then they just say, and by the way, when you're there, don't do this and don't do that.
Well, I don't know if I agree with that. I think that there is a trend here to incorporate immigrants of all kinds into the body politic of the Republic, and this gains expression later in the century, when something I raised with Richard yesterday, when Jews find themselves in trouble abroad, they're protected as Dutch subjects.
But there
They
are
are-
precedents for that in the 16th century already. There are lots of precedents where states
I'm not
are
saying there
Jews
aren't
and-
precedents,
and
but what I'm
therefore
saying
are
is that there is this, I think, what I see as the most important trend here is the effort to avoid special legislation for Jews. They're recognized as Jews, but there's no special legislation for them. And that's the novelty. That for the most part, they're regulated by the laws of the land, as is reiterated in this brief document. And they need to discipline their own, but as a religious group in the same way that the Reformed consistory regulates its own members.
I had to step out for a moment, so if you address these questions while I was out, I apologize.
Just tell me that. I have a few questions. I'm struck by the first phrase, representatives of the Jewish nation. Not the nation part so much, because we've talked about that, but the representatives, and who they are, how are they constituted, do you know anything about that? And this is linked to my second question, which is, you said that the Beit Din was recognized. There's no hint of that in here, so I'm wondering how, what that process was. Was it a formal recognition? Was it a legal recognition? You wouldn't, if you just read this and you knew nothing else about Amsterdam, you would see that the leaders of some representatives or leaders of this group of individuals probably will be invested with some kind of responsibility for keeping their members in line. But you wouldn't necessarily imagine a Beit Din being recognized in any way by civic authorities. And also in regulation, you said something about later regulations about where the Jews could live and their residence.
About later legislation?
I thought you said there were later regulations about where they could live.
No, there was never regulation.
Oh. Maybe I misheard you.
well,
So
as
the representatives and the Beit Din.
Okay, the representatives clearly the intention here was to make it known to all Jews, to make these provisions known to all Jews. The excuse of ignorance will not be accepted. I imagine that members of the Ma'amad were here and that these things were posted in the synagogue and that they were mentioned. I don't know who they were. It says they arrived in sufficient number, but I have no idea who they were precisely.
Barbara, do you have a question?
The Beit Din, as Anne pointed out earlier, in general, the authorities supported the Ma'amad against private parties in matters that concern the community. So that, as a matter of policy, this was a matter of maintaining order. Portuguese Jews were constantly using Dutch courts. For economic matters, they used only the Dutch courts. If there was a dispute between two communities that they could not resolve, it could be taken to a Dutch court, but I think that was true in many places. Again, it's just an absence of reference to it. I don't think that the way things were actually, the way they actually operated was different from elsewhere.
Barbara?
Just a very short question. I don't know if I understood you right about the oath. You said that the oath is mild.
Relative
Compared
to some
to
forms
what?
of-
Because I know those oaths like this from the German lands, from Austrian lands, and I was wondering compared to what it is mild.
I should have brought some examples, and I didn't.
To other oaths from the Netherlands or...
Oh, not from the Netherlands. No. I was thinking of perhaps Elisheva. You.
Certainly mild compared to.
Try it. Anne, you had a question?
Well, yeah, I just wanted to, I'm still thinking about what, as John was thinking about what parallels there might have been from the Dutch perspective for a Jewish community like this. I mean, you raised the question. And you suggested that the Dutch authorities thought that the Jews should discipline their own just as the consistories. And I guess, this is my ignorance, I don't really know, in the consistories, was there discipline concerning non-religious affairs, or were you just talking about their religious orthodoxy? Or was there anything like the way that the Ma'amad had control over mercantile activities, behavior in the streets, all aspects of life that might otherwise come under Dutch civil and criminal law, right?
No.
So the Ma'amad had this much broader authority over things that were not purely religious. Right? I'm wondering
I agree with you. And the disciplining was religious and moral. And, there is a moral streak in this regulation, and there was concern about that. There was, deep concern about that. But there was certainly among the more humanistically minded regions this sense of civil decency that we've talked about a lot, and that's what had to be maintained. That the specifics of discipline within any given religious group was their own matter to tend to. But in what was done in public that was considered an offense to public decency, they had a right to act in those matters, even though they rarely did.
Shalom and Stephanie, and then see what we
I
say.
want to take up your question from an angle it may not be your intention, in the hope that you or some of the people in the history of continental law might have insight here. This word representative, what does it really mean for a particular person to be a representative of a community, representative of somebody else? The English word representative, I know that there's a history in your scholarship in political philosophy as to exactly what that could mean.
I really need to talk about translation here.
And I look here, I have very little experience faking the ability to read Dutch. Dutch. But it's clear to me that since my ability to speak German is a lot better, that gerecht is not exactly representation.
No,
Somehow,
that's not
de gerecht, die van de Jüdische,
Herren van de Gericht, the magistrate of the court.
page 7. I think
Representative is actually here, and
I have it. So gerecht would then translate what?
Magistrates of the court.
Isn't Herren van de Gericht magistrate of the
Yeah.
court? Judicial.
In the rightful Herren?
No. Recht is a word that has a legal, means the court.
Court.
Because
but it's
But why
not,
the
but it doesn't
magistrates?
mean, but it doesn't mean, I mean, it's.
I mean, gerecht would have
What do you-
But what
Community
is
of the
the
court.
parallel? They're using language that parallels their own position as magistrates. So perhaps it should be, I mean, it would sound very odd, the magistrates of the Jewish nation. And I assume it would be the Parnasim plus some others. Right. I mean, what raises the question for me whether it's just the Parnasim is, and they arrived in sufficient number, which sounds as if they called an assembly. So I'm not sure.
It's also important to note that this is before there was one community, right? So they may have required that representatives from the
All
various
three.
congregations. So a sufficient number might be from.
Stephanie?
Yeah, I back onto the other
Topic of the model that you presented to us, the political model of the Dutch tolerance, which perhaps dependent on or enabled by, or maybe even best productive of very tight discipline within these religious groups, including our Ma'amad. So in that context, the question, I know more just because I've read more about Amsterdam than what's happening with Cherem in other places. We heard about Hamburg. I don't know very much about Cherem elsewhere in the world. I'm wondering, is your model, is it your impression at this point that this model of tolerance might help us understand Amsterdam, the Ma'amad, as a more repressive or more effectively disciplinarian self-governing system than we would find elsewhere? I mean, is the reason I'm reading about Cherem more often in Amsterdam because there is more of it there than in places where there's less tolerance?
Quite possibly. Quite possibly. When there are no pressures from without, the centrifugal forces are stronger, and this is a particularly ungovernable group, as you know. But I also think that Anne's point was very important, that the Ma'amad had very strong support from the magistrates and the states of Holland, and that permitted them to exercise the cherem. It was exercised rather freely. Some could say that was a way of sort of disabling the cherem. It became almost trivial when somebody was put in cherem for one day for having made noise in shul with a neighbor. I don't think the discipline in the Amsterdam community was particularly, it doesn't really seem very strict. I just think that the assumption was that the Ma'amad would take care of those matters, and the state would support the Ma'amad and be hands-off, partly because it was a religious community, and partly because it was there was a distaste for getting involved in religious affairs.
Thank you very much, Miriam. We're going to do a little sit change.